Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to your next instalment for Unit 3 of Criminology. This one is for 2.3. So let me make myself smaller and we'll get cracking. Alright, so this topic on 2.3 is understand rules in relation to the use of evidence. First thing I got my students to do was to consider all the evidence in all the cases that we've looked at so far and to write a list of the different kinds of evidence and how they might be unreliable or problematic when presenting them in court. And so we discussed things like the Amanda Knox case and the bra strap. We discussed in the case of Sally Clark and the expert witness evidence. We discussed about the use of other witnesses in other cases. We looked at how DNA was found, but it might have been contaminated. So we looked at all the different kinds of evidence and how they were unreliable or presented problems. So the things that you need to know. You need to know relevance and admissibility, disclosure, hearsay rules and exceptions, and then legislation and case law. Legislation and case law does not have a separate section on this PowerPoint, so I've highlighted the different relevant sections in green so that the legislation sections for what you need for your controlled assessment stand out. So again, you need to have an understanding of how evidence is used in court. So relevance and admissibility of evidence. In a trial, both the prosecution and the defence can present evidence to support their case, and it must be reliable, relevant and admissible. So I got my class to first of all guess what they think each of these means. How does it apply? Got them then to look up the meaning of the words, just to really get an understanding of what these words stand for and what they mean, and then how that then links to evidence. So reliability, the first question is the evidence true and dependable? Is it accurate? So is it accurate in all the details? So for example, if an expert witness is being called to testify, for it to be accurate, it must have scientific support from other professional experts who can vouch for it. This is why the Sally Clark case is a very interesting one for this one, because obviously the two expert witnesses, Sir Roy Meadows and the paediatrician worked alone, and so when he gave his verdict on the second son and then changed his decisions on the first one to say that both had shown malpractice and murder, and then Sir Roy gave the idea of the statistics, etc., and this wasn't backed up, this wasn't verified, this wasn't scientific, wasn't the statistical analysis that he gave, the 1 in 73 million chance of it happening to the same family in her conditions twice. They were able to take that information forward, but was it really accurate? Is it authentic? Is it genuine? For example, for a document being used as evidence, it has to be authentic. It must not be forged. So again, this is very interesting when looking at things like Hillsborough. A lot of the police statements were changed, they were adapted, they were asked to go back and add things in, sentences were taken out. So whilst it wasn't completely forged, they were doctored in some way. Is it credible? Is it believable? If a person is called as an eyewitness to be credible, it should be shown that they are of good character and not a persistent liar. And again, this is where the Damilola Taylor case comes in, and their eyewitness Bromley, there you go, Bromley, the young girl that was their witness. It was unclear due to her character, due to the way the police treated her with potential bribery, etc., whether she was actually credible or not. And again, it was thrown out of court later on and should have been recognised by the CPS. It should have been called out by them that this witness was not reliable or credible, and so the judge ended up calling her a liar. And so then again, the case fell down. The relevance then of evidence in court. You have two types. You have, first of all, facts in issue, the principal facts, the key facts. These are the main things the court are there to make a decision about, the issues in dispute and question. For example, did person A murder person B with a kitchen knife? Did they do it intentionally? Because then you've got whether it's murder or manslaughter. Was the stabbing the actual cause of death? So did the stabbing lead to the person's death? And then you have relevant facts, facts related to these, things that help, the facts presented to support the facts in issue, to prove or disprove the arguments made by the prosecution or defence, e.g. person A's fingerprints are on the knife handle and person B's blood is on the blade. And can an expert witness doctor confirm that person B died as a result of the stab wound? So it's about the evidence that then goes to back up the principal facts, the facts in issue. The last section for this bit is the admissibility of evidence in court. Courts only allow certain kinds of evidence to be heard in a trial. Certain kinds of evidence are inadmissible. So again, can you think of any, so I got my students to think about, was there any evidence that was not admitted in court that was inadmissible? And again, there's a lot in the Amanda Knox case, there's a lot of evidence in that case that was not allowed at the trial because the blood or the saliva was inconclusive. It could have, the mixed saliva in the bathroom could have got there by different means. The blood was far too small to really show that it was Meredith Kircher's blood or to show who was actually holding the knife, etc. And so then I got my students to research the different types of inadmissible evidence. So how it's improperly obtained, illegally obtained, pre-trial silence and bad character. And I got them to also make sure that they focused on the areas in green. So how it's improperly obtained, and they need to look at 78 Pace 1984, because again, that's the legislation they need to reference. They looked at pre-trial silence, which is part of the Criminal Justice and Public Act Order, Order Act of 1994, and then bad character, which again is Criminal Justice Act 2003. So those are the legislations that you also need to refer to. And then I got them to look at, again, case study examples and their specifics. The second then is this disclosure of evidence in court. This is found in the Criminal Procedure and Investigations Act of 1996, the CPIA. And it was amended in 2003 to become the CJA, the Criminal Justice Act. And we've covered this, I think it's either in a future topic or a topic that we've already, I think it might be in a future topic. The prosecution must reveal all evidence in its possession, even things it doesn't plan to use in court. So they have to present everything that they have. It's interesting how the defence does not have to do this. The defence could find evidence that is slandering. They could find evidence against their client that is very, very damning. If the prosecution don't find it, the defence do not have to release that evidence. So I got my class to discuss why they think this is. So again, there can be no veil. The defence needs to be able to counter all evidence. The defence team have a duty of disclosure. This means they must tell the prosecution in writing what their main line of defence will be, what aspects of the prosecution they will challenge. So they have to, the defence has to then say what lines of argument they're going to go down, what evidence they're going to go after, what they're going to question. So again, this gives the prosecution a chance to fill any gaps, to prepare to then counter that defence. So it's all very scripted. It's all done very much behind the scenes before you even get to that courtroom, that jury, etc. But the defence don't have to disclose any unused evidence, as I've mentioned. If the prosecution failed to disclose evidence, this can cause the trial to collapse or serious miscarriages of justice. And so again, I got my students to look at Sally Clark. I got them to look at the evidence that was withheld by the prosecution and the people prosecuting Sally Clark. So that again is the paediatrician and Sir Roy Meadows, and how they withheld that information. So it wasn't the prosecution themselves withholding the information, it was the actual individuals they called up that withheld the information. And I got them to research the case of Liam Allen, who was accused of rape, and again, what evidence was withheld in this case. Number 3 is hearsay evidence in court. Hearsay is A statement not made in oral evidence in the proceedings that is evidence of any matter stated. This is again the CGA 2003 section 11414. Again, you need to know what legislation it comes from. In other words, evidence given by a witness that another person has stated something to them, so outside of court. So it's where evidence, so it's somebody else that's heard someone else say it. So someone might have witnessed it, told someone else, it's that someone else that then comes forward. So a witness is using this as evidence in court. So for example, Toby told me that he saw Michael in the newsagent shop at 6 p.m. This is not admitted in court ordinarily. Why? So again, I got my students to discuss why, because hearsay, Chinese whispers, things change, they didn't see it directly. How do they know that the information that was given to them was accurate? So also because Toby is not there to swear an oath, also not there to be cross-examined. So there's a number of reasons why hearsay is not allowed. However, the exceptions are if a person who witnessed something has disappeared. So if the person disappeared and they told somebody else, that someone else can then come forward. They've gone abroad, is unfit to testify due to mental or physical conditions if it would cause trauma, is too afraid, though this reason can't be used unless the court considers it needs to be in the interest of justice, because again, they can do it at home in a separate room, they can do it by video link, so they make ways around if they're too afraid to do it. So again, it has to be very specific to the case as to why they're then not allowed to give evidence themselves, or has died. B, also, if defence, the prosecution and judge all agree to it being used, it is allowable. So if the defence, prosecution and judge all agree, why would the defence though agree? If they know that some information that's been given in hearsay is damaging or damning to their client, they're not going to agree to it, they're not going to allow to it. The person who witnessed something must be identified to the court's satisfaction. Now, this is very, very interesting in the Colin Pitchfork case, because if you remember the Colin Pitchfork case where Colin Pitchfork murdered the 15-year-old girl, 3 years later killed another 15-year-old girl and raped them, and they had the semen, they knew the person was type A blood, they had somebody else they thought it was, but that then fell through, and the reason that Colin Pitchfork was found was because he told somebody, that someone had then gone to the pub, bragged about it with other people, and a woman overheard the man bragging. So the man that worked with Colin Pitchfork at the bakery, Colin Pitchfork had made up some story about how something about indecent, he'd done something wrong, so he didn't want the police to find him. So he said to his friend at the bakery, "Oh, will you just give Mark your DNA to them? Will you just," because they did 5,500 swabs of DNA around the area to get a database of DNA, and Colin Pitchfork knew that he'd be caught back through that process, so he asked his friend to give his DNA pretending to be Colin Pitchfork, and he did, and then he bragged about it, the man that gave his DNA for him, at the pub. A woman overheard, took it to the police, and therefore they were able to catch Colin Pitchfork. Now, that was hearsay. She'd only heard a man bragging at the pub that this is what he'd done, but they were, because of the situation, they were able to investigate into it, get his DNA from him, and then obviously find that he was guilty. So that was then allowed. But in the Jeremy Bamber case, which is a case that I look at with my students in a few topics time, so I'd really recommend you look at the Jeremy Bamber case, really interesting one. It's the last one that I did with my class. Is that one of the key witnesses was a scorned ex-girlfriend that turned around and said she'd overheard a conversation on the phone at one point, and then she said actually he'd said it to her face that he was going to kill his family. But if she'd overheard him on the phone, then that could be classed as hearsay. She doesn't know what the person on the other end of the phone's saying. She's not part of that conversation. So again, that was quite questionable as potential hearsay. So there's some really good links that you could make with that one. All right, nice and short and sweet. Hopefully you found that useful. Don't forget you have to link it into the legislation as well. And this is about, and give you case studies. You can mention your brief if you can, your controlled assessment. But this one is about whether the evidence will actually stand up in court or not, and how it might be accepted or dismissed. Please feel free to drop me a comment underneath if you do have any questions. Don't forget to subscribe as well, so you'll always stay up to date with all the latest releases of videos. Otherwise, thanks very much everyone. Bye for now.